You've just been charged with destruction of property, and now you're staring down fines, jail time, and a record that could follow you for years. You're probably wondering if you even have a defense or if the DA already has everything they need to convict you. I'm John Cannon, a criminal defense attorney here in Oklahoma, and I tell people walk away from charges like this by doing something simple. We don't panic, we don't guess, we make the state prove their case. In this video, I'll show you how we challenge the evidence, expose weak spots, and use Oklahoma law to fight back so you can protect your record, stay out of jail, and move on without this charge ruining your future. Because the biggest mistake people make in property damage cases is not the damage. It's what they say afterwards that locks them into the story the state wants. All right, let's get into it. First, quick clarity, because the wording matters. A lot of people call it destruction of property. In Oklahoma, these cases often get filed under property damage laws like malicious injury to property or vandalism type charges. Different facts can lead to different specific charges, but the theme is the same. The state is claiming you damaged something that wasn't yours. And it does not have to be dramatic. It can be a mailbox, a window, a car door, a fence, a tire, a sign. It could be graffiti, a phone, anything. Here's what makes these cases dangerous though. People treat it like it's just property, but the system doesn't. You can be looking at restitution, fines, probation conditions, possibly jail time, and a record that can stick. And there's another part people don't see coming. Even if the criminal case ends, the property owner can still try to come after you civilly. So if you handle this wrong, it can keep costing you potentially for years. Now, the good news, these cases are often more defendable than people think, because the state has to prove specific things. They can't just say property got damaged and call it a day. Which brings us to the first move that actually protects you. If police want to talk to you about a property damage incident, your job is not to convince them you're a good person. Your job is to not hand them a confession, because property damage cases are full of half confessions. Stuff like, I didn't mean to break it. I barely touched it. I was mad, but I wasn't trying to cause damage. I was there, but it wasn't like that. I get why people say that. They're trying to be honest. They're trying to calm things down. They're trying to resolve the situation. But in court and in police reports, those statements become intent, admissions, motive, all wrapped into one. Here's the trap. If you admit you did the act, now the fight gets harder. The state only needs a few building blocks to turn your explanation into a win in their case. So the clean move is simple. Be respectful, be calm, say, I want to talk to my attorney. Then stop talking. Not because you're guilty, because you're smart. Now, once you stop giving the state free evidence, we do the next thing that wins these cases. We take apart what the prosecution has to prove. Remember, shut up and lawyer up. In an Oklahoma property damage case like this, the prosecution is usually trying to prove four things. 1, there was real damage. 2, the property belonged to someone else. 3, you caused the damage. And 4, you did it on purpose, meaning maliciously, not by accident. If they can't prove all 4, the case weakens and can be dismissed. So we look for common cracks. Was the damage already there? Was it actually damaged? Or is this a disagreement when someone wants you to pay? Did anyone actually see you do it? Or are they assuming? Is there video, or is this built on a complaint and a guess? Because a lot of these cases are not caught in the act. They're built on a story someone tells, then a report gets written, and suddenly you're the defendant. That's where defense lives. Now, the beginning pressure point in almost every one of these cases is intent. So let's talk about intent, because this is where most people win or lose their case. Intent is the battlefield, not the broken window. The state does not just have to show something got damaged. They have to show you meant to damage it, or you acted in a way that basically says you didn't care what happens. That's what separates a crime from an accident. So we ask questions like, what happened right before the damage? Was this a slip, a trip, a misunderstanding, an accident? Is there anything that supports this was not malicious? And here's what people underestimate. Details that seem small can matter a lot when it comes to intent. Lighting, weather, footing, crowded spaces. Alcohol doesn't automatically prove intent. Anger doesn't automatically prove intent. Being nearby doesn't automatically prove intent. Here's some example scenarios. A neighbor says he was mad and broke my light, but nobody actually saw it. So we don't argue feelings, we build facts. We take photos of the area. We look at the path. We talk to witnesses. We look for video. We look for anything that supports accident over malicious intent. Because if the DA can't prove intent, the case starts to crumble. Now, the next pressure point is identity, because another common problem is the state assuming that it was you. This happens more than people realize. Someone hears a noise. They see a person walking away. they've had issue with you before, and they connect the dots. Then the story becomes, I know it was him. But court is not supposed to run on assumptions, so we test the reliability of the accusation. Did anyone actually see you damage the property, or did they just see you near it? Is the video clear, or is it a blurry clip when it could be anyone? Was it dark? Was it chaotic? Are there inconsistencies in what the witness say? And we also look for motive to accuse. Neighbor disputes, breakups, custody issues, workplace drama. I'm not saying everyone is lying, I'm saying people are human, and assumptions get people charged. Now, let's talk about the thing that can change this case overnight: the number, the damage amount. In Oklahoma, property damage cases often swing around a threshold near $1,000. Below that, you're usually looking at a misdemeanor version, much less serious circumstance. At $1,000 or above, your case can move into felony territory. And in some situations, prior history can raise the stakes too. So the value matters a lot. Here's the trap. The state often leans on the property owner's estimate. Sometimes it's inflated. Sometimes it's full replacement cost when a repair is cheaper. Sometimes it includes damage that wasn't part of the incident. So we challenge it. We ask for documentation, invoices, quotes, photos, receipts, repair records. And we also look at whether the state is adding multiple items together to reach a higher charge threshold. Every line item matters in these cases, because if we can show some damage was pre-existing, or some wasn't caused by you at all, or the numbers are exaggerated, the case can drop from felony to misdemeanor or get a lot more negotiable. Now, once we've attacked intent, identity, and the amount, we do something that wins these cases. We replace the police report story with real evidence. The police report is not the truth. It is one version, often based on what someone told an officer, sometimes with assumptions baked in. So we bring proof, photos, videos from doorbells or businesses, texts with timestamps, witnesses who are not emotionally involved, anything that locks down the timeline, the rest of the story. And sometimes one piece of evidence changes everything in a case. A camera shows someone else did it. A timestamp proves you weren't there. A photo shows the damage existed before. This is why acting early matters. Videos get overwritten or deleted. Witnesses disappear. People's memories change and fade. Now, I need to say this part clearly. Sometimes the case does not get dismissed. That does not mean that you're out of options. It means you need to negotiate smart. Not every destruction of property case is an all or nothing fight. Sometimes the best outcome is a reduction in your charges. Sometimes it's a deferred sentence where you complete conditions that keep a conviction and jail out of sight. Sometimes it's restitution in a way that closes the case without wrecking your future. But here's the rule. You don't take the first offer just because you're scared. You pressure test the state's case first because they have the burden. The DA knows you can challenge intent, identity, and the amount of the damages. And sometimes the deals change. Leverage comes from preparation. Now, a quick reality check. If you get convicted, penalties depend on the charge level, the amount of damage, your record, and the facts. It can mean fines, restitution, probation, community service, and jail exposure in some cases. But the bigger issue is record. A conviction can follow your employment, housing, and anything involving background checks. That's why the goal is not just get it over with. The goal is get the best outcome that protects your future. Now, let's close with the move that gives you the most options. If you're watching this, you're probably stressed. You're probably scared. We know, and it is normal. But don't do what most people do, which is wait and hope it sorts itself out. Early action preserves video. Early action locks in witness statements. Early action gives your defense team time to challenge the numbers and the facts. Early action gives us time to build a clean narrative from evidence. And it keeps you from making the biggest mistake I mentioned at the start. Here it is. People talk about the incident afterward. They text the property owner. They apologize. They offer to pay just to make it go away. They post. They vent to coworkers. They try to explain. They create evidence. They talk to the cops. So keep your case off the phone. Don't talk to the cops. Talk to your lawyer. Remember, shut up and lawyer up. Let your defense be strategy, not panic. Here's what we learned today. In an Oklahoma destruction of property case, we don't just argue. We attack the checklist, we challenge intent, we challenge identity, we challenge the damage amount, and we challenge the evidence. And if we use real proof to replace what the story is in the police report, that's how people beat these charges, reduce them, or get outcomes to protect their record and their future. Now, if you want to stay out of even bigger trouble, watch my next video, Assault or Self-Defense. Learn how to dismiss your charges. Click that video now, and I'll see you over there.